Well, thank you, Stephanie. I'm Kevin. This is my colleague Matthew, and welcome to the Basics of Corporate Law, presented to you by Kaiser Mason Ball, LLP, affectionately known as K&B Law. We're going to run you through some various scenarios, some common questions, some common pitfalls and challenges that small to medium-sized business owners go through as they operate their businesses, in terms of their structure, in terms of their operations, and in terms of maybe little things that have been bothering them or questions they've had. We're hoping to answer them today. So thanks for joining us. Well, any good presentation by a law firm wouldn't be good unless we told you a bit about us. So the Coles Notes version, as you can see on the screen, is we've been around for more than 40 years. We're a practical, collaborative law firm that helps small and medium-sized business owners, typically private business owners, operate their businesses. We provide a full suite of legal services to those business owners, everything from employment law to corporate commercial, intellectual property, litigation, family law, and so on and so forth. We are here to present today because we are committed to the community in Mississauga, and we look forward to working with you as we have in the past, our dedicated small, medium-sized business owners. Of course, any legal presentation would not be that without a disclaimer. So you'll see the disclaimer on the top there, but I'll give you another Coles Notes. The information provided in today's presentation is just that. It's information. We're here to provide some different scenarios, but it doesn't replace legal advice. You are encouraged to go out and seek legal advice from your own lawyer, retain them, and they can help you with your unique circumstances. Every situation is different, and your lawyer will be able to help you with that. Today's for information purposes only. So we're hoping today to kind of go through some of the basics. And so what those basics entail are a division of, hey, how should I operate my business? Well, we see the three basic structures below: the sole proprietorship, the partnership, and the corporation. But why might you pick one of those three structures? Well, that's really driven by a couple of things, and those are at the top half of the slide. Quite often, if you look at a scale or a wage scale, you've got liability, that's the lawyer side of things, and tax. Hey, what's the most tax efficient way to deal with things? That's more of an accountant type thing. But together, those kind of make up the decision-making factors for most small and medium-sized business owners, and of course for larger business owners as well. But for today's audience, kind of think of those two things. And that should be a theme that we kind of run through on today's presentation, because the nature of how you operate your business and how much risk you're willing to take will really drive what structure works best for you. The other thing that's nice about corporate law is there's some fluidity to it. So just because you start your business as a sole proprietorship doesn't mean that you can't then later operate your business as a corporation. And we'll operate on the assumption that by giving you the basics, we can then walk you through some of the transactions towards the end that let you change or shift your structure as you go. Over to you, Matthew.
Sure. So you'll see from the previous slide, there are three basic corporate structures, or three basic structures of running your business. And the most simplest and easiest one to form and run is the sole proprietorship, or a sole practitioner. In this case, there's no separate legal entity. The individual who's operating the business is the business. So that single person or persons at the end of the day, they own all the income and assets, but they also have all the obligations and liabilities. So any type of loss, that attaches to them directly. There is no limitation of liability either. So for example, if you're going to be entering into a contract and that contract has certain obligations that need to be fulfilled, they don't just stop when your business operations stop. They can continue and flow to you directly through your personal assets. You also have liability for employee actions. So if there's any type of vicarious liability, for example, if you hire a subordinate who goes and completes some type of tasks for your business and there's some type of improper way that they've completed their task, that can flow back to you directly. Now, of course, there are certain ways that you can limit your liability when you're a sole practitioner. You can have certain types of insurance. You can also sort of put in protections in your contract that you might be entering into. But at the end of the day, it is that sole individual who's bearing all that liability responsibility.
So if you think about it kind of in an analogy, imagine because that sole proprietorship is the same as you are the sole proprietorship. All the income, all the assets, all the liability, loss flows to you onto your personal tax return, your personal income, personal assets. Think of it kind of like holding a postcard in front of you. You are holding it, you are still the one operating the business. So you can register what's called a master business license, and that says that's what my sole proprietorship is. You get your tax number, but really at the end of the day, you report it on your own income. You take on the benefits and the losses, and that's why it's so easy to set up. There's not a separate legal entity. Matt's comment about risk is also really important because it comes down to that liability component. And a lot of people say, hey, I'm a sole proprietor, I'm a corporation, I'm a partnership. You know what? It's okay. I'm just going to get in some insurance. It's going to be fine. Well, insurance is one leg of the three-legged liability stool. And the way we think about it is you can have insurance, and insurance is great. Commercial general liability insurance, errors and emissions insurance if you need that, specific riders that are applicable to your business. Your insurance broker, your insurance professional can help you with those. But it's only one leg of the stool. If you have a stool that's held up by one leg, you know what's going to happen to that stool. Contracts are another leg. So when we say contracts, a contract can have things like waivers built into it. It can have limitations of liability. It can have things that have to do with, exclusions, etc. And finally, your structure will dictate your ability to protect yourself from risk and liability. And we'll kind of build on that as we go through our presentation. So the next form of operating a business is a partnership. And a partnership, we hear a lot about them. Hey, Matt and I are partners. This is my partner. A partnership is something unique in law. And what we mean by that is, we're going to talk about general partnerships today. There are other forms. We'll get to those in a minute. But for example, a partnership is a creature of statute. And it's pretty simple to set up. It's just two or more people carrying on a business in common with a view to making a profit. Now, time to throw a wrench in. A person can also be a corporation. And we'll get to that in a minute. But the idea is that if you're running a partnership, obviously you can't run it by yourself. You need to have someone else with you, be it a corporation or another entity. But all profits, losses, liability, risk, etc., flows through. So when you have a partnership, the partnership doesn't hold on to those types of things. They flow out to their partners. Now we hear about things such as limited liability partnerships. Hey, we work at one, an LLP. Those are typically for accountants and lawyers and certain professionals. And then you hear things about limited partnerships. And limited partnerships are very popular when it comes to raising money, fund structuring, certain types of corporate transactions. But again, in that scenario, the profit and loss has to be allocated, distributed out to the various partners, and they're governed by different acts. These are very act-driven type of structures, and typically for a small to medium-sized business, unless there's an express purpose to having it, usually tax-driven or liability-driven, most people don't operate in a true partnership. They're just a little bit more wieldy to operate, manage, maintain, report tax, etc. But with any good relationship, you can have your act, which is the governing legislation, the Partnership Act, etc. However, you should also have a relationship document. We'll talk about relationship documents in a little bit, because determining what people's rights vis-a-vis one another are as partners really comes down to how you structure your actual relationship and the terms upon your entering that relationship and managing that relationship as you play it out through. But with that, we've got sole proprietorships, we've got partnerships. Everyone get ready for a little bit of a mental drum roll, because here is the favorite one for the lawyers when it comes to liability protection. Over to you, Matthew, to talk about corporations.
Exactly. So obviously, us being lawyers, we're somewhat risk adverse. We also like the idea of being able to really separate a business owner from the business actions themselves. And now there's nothing wrong with the sole practitioner sort of practicing the way that they do and operating the business that way. It's the easiest one to form. It's the cheapest one to form. You don't have to dissolve it. You don't have to maintain it. With corporation, that's a little bit different. Corporations, it's its own legal entity. A corporation can enter into an agreement. It can enter into a contract for purchasing assets. It can sell its assets. It can even own real estate. Now, the nice thing about corporations is that there's less personal risk for the business owner themselves. So the shareholders, the business owner, have more limited liability. Now, obviously, risk can increase when you're securing financing, and a bank might require a personal guarantee of the business owner. But at the same time, there is a division between the business owner and the business themselves, what we sometimes refer to as the corporate veil, in that there is someone behind the organization, and that person behind the organization, being the shareholder, is separate and apart from the corporation itself. Now, unless a court finds that you've gone ahead and created this corporation to specifically skirt certain laws or tax liabilities, it's very difficult to pierce this corporate veil, and a lengthy process through the courts to do so. Now, it's also important to understand that corporations, being their own separate legal entity, they require certain types of upkeep. It's not something you can just create and then forget about. Later on in our presentation, we'll sort of talk about how to upkeep a corporation and maintain it, whether it's through its annual filings or annual resolutions. But at the same time, it's important to note that corporations also have the benefit of having more than one business owner. You can have multiple shareholders, obviously. So whether it's a business partner, group of friends, some family members, or outside investors, it allows for different ways to raise capital, but also structure a business. Now, when you have more than one shareholder, it's obviously important to think about the relationships between them. This is where shareholders agreements come into play. And shareholders agreements, Kevin has a great analogy that he always likes to use, is used to not only govern the way that the corporation works, but also specific types of buckets that fall into operating a business.
And that relationship is similar to that partnership discussion. When you're entering into a relationship as partners, you should set out how you're going to treat each other at the beginning, while it's operating, and at the end. And those buckets Matthew talks about are very relationship driven. So, hey, we have a closed system. Who else can get into this? Well, no, here are the terms that we can bring on other shareholders. Okay, how are we going to manage the affairs of the corporation? Our day-to-day check signing and directors and officers and that kind of thing. Then what do you do if someone wants it? I don't want to be in this relationship anymore. I'm going to let you in a little secret. The Business Corporations Act doesn't have a lot of mechanisms other than application to court to be able to have a corporate divorce. Divorce sounds very nasty, but that's what it can be. What a shareholders agreement does is, while people are friendly with one another, they pre-agree how they will deal with someone wanting to leave, what options, what's rights, etc. And then what do you do if someone needs to leave? So the first one is when someone wants to leave. What if someone needs to leave? Death, disability, bankruptcy, divorce, etc. Those are all scenarios where I may not want to have a shareholder involved, or that shareholder may not be able to be involved as a shareholder. How do we deal with that type of scenario, knowing that the Act doesn't have a lot of wherewithal to support us? But before we get too far down the rabbit hole, why don't we talk about the corporate structure a bit more? So, we talked about we want to set up a sole proprietorship. Okay, you file that master business license. Okay, boom, I'm a sole proprietor. Got my name, no separate legal entity. Partnership, depending on your type of partnership, you got to file a Form 3 or similar form to create that partnership. Other ones can be partnerships at will, like a general partnership. Okay, great. Well, what about corporations? How do they get started? Let's talk about that in the next slide. So the first step is the filing of articles of incorporation. And a lot of people say, super easy. I can go online, there's the Ontario Business Registry. Relatively new, you can go online, you can file your own articles. Through Corporations Canada, you can also file your own articles. But hold on, flag on the play. How come I can file articles at an Ontario Business Registry and can also file them at Corporations Canada? What's the difference? Well, the difference is the jurisdiction under which you are incorporating. So the first bullet is a kind of a primer for us to say, well, okay, why might I pick one or the other? And there's a couple of factors. Well, first of all, relatively the cost, the filing fees, the stuff to actually incorporate, they're relatively similar. and your ongoing maintenance, your annual returns, relatively similar. Okay, but why might I pick one over the other? Well, one reason might be where you're operating. Hey, I want to operate only in Ontario. Great, maybe you pick an Ontario corporation. Hey, I want to set up a federal corporation and then extra provincially register in a bunch of different provinces. Okay, that might be another reason to do it. You can still do it with an Ontario corporation, but if you do it federally, you tend to be able to have a little bit more flexibility, we find, to go to other provinces. Hey, I already have 4 federal corporations in my corporate group. Should I pick an Ontario corporation or a federal corporation? Probably going to say pick a federal corporation, because if the business doesn't go the way you want it, you have losses or it doesn't go the way you want it to go, you can always amalgamate. We'll talk about amalgamation later. So there's a couple of reasons why you might pick one or the other, but either way, they're called articles of incorporation. And in other provinces, they have terms like articles of association. I did law school in Nova Scotia, so that's what they call them out there. It's the same idea. It's a constating document. And we'll go through a funny little analogy in a little bit to kind of think about things, but those are the birth certificate for the corporation. That's the filed document. And if you want to make changes to that, there's a certain process. You don't just write on it and change it. It's a filed document. And it contains the name of the company. It contains the number of directors, the range on there, or the set number, and the initial directors. It also sets out the authorized share classes, the share capital, and the rights attached to them. So those rights could include, or should include, voting rights, dividend rights, and participation rights. What do you mean by participation rights? Well, participation in the case of wind up or dissolution. Hey, I got some money I want to distribute it out. Hey, I'm dissolving or winding up. Where do those assets go? There are provisions built into the share attributes that talk about how that process goes. It's your main constating document. That's step 1. Guess what? When there's step 1, there's usually a step 2, and I'll hand it over to Matt to talk about step 2.
Exactly. So at the end of the day, the articles of incorporation are what create the company itself. And that's all great. You've got the company created. But step 2 is, okay, who are my directors beyond the first directors that are listed in the articles? Who are my officers? Who are my shareholders? What are the bylaws, etc.? And that is dealt with in the step 2 of sort of creating your company, which is organizing it. And so now,
Matt, wait, I don't get any shareholders when I incorporate?
No. Unfortunately, there are limited things that the articles of incorporation provide. And what Kevin kind of listed there is that those sort of basic requirements, the name of the company, the number of directors, and the authorized shares. So that basically means what shares can you issue. That doesn't necessarily mean that the shares have been issued. So when we talk about organizing the company, this is where we go ahead and we say, okay, who are the shareholders going to be? What shares are they going to get? What's the subscription value that they're going to be subscribed for? Now that we have our shareholders, we can go ahead and elect the directors. Now, the way that the companies are structured is that each part of it has a specific role to play. So the articles of incorporation create the company, but the shareholders are the ones who take to the next step. They're the ones who elect the directors. And we'll talk about responsibilities and roles of directors and officers later, but at the same time, it's the shareholders who elect the directors. Okay, now that the directors are elected, who are the officers? Well, the directors will go ahead and they'll appoint the officers. Okay, great. Now we have officers, directors, and shareholders. What comes next? Well, you want to have a system of bylaws. So sort of the internal procedures that govern how the business is operated, who can do what, the signing authorities, etc. Okay, great. Now we have bylaws as well. What else should we think about? Well, we should think about who are our accountants going to be? Who are our lawyers going to be? What's our fiscal year end going to be set as? December 31st? Well, that's easy. But is there a different reason that we might want to have it at a different point in time? Whether your business is different, cyclical, seasonal, etc. And importantly as well, you might, if you're a small corporation with a limited number of shareholders, or even a larger corporation with multiple shareholders and third parties, you'll want to consider waiving audit provisions.
And now for the funny analogy, because most people I'm sure on this call might be rolling their eyes. You got 2 lawyers, you know what, they're just trying to drum up business. That's all they're doing here. They made this up. It's complete fabrication just to drum up business. And sure, yes, we do charge you this type of work. I'm not going to pretend we don't. But there's a purpose behind it. And if you think we're making it up, maybe you are, maybe some of you are smiling, I invite you to open the Canada Business Corporations Act or the Business Corporations Act Ontario, and don't read the whole thing unless you have some time and a good coffee, but go read the table of contents, because the table of contents will settle a lot of these themes. You're going to go, oh, shareholders, directors, officers, right? This stuff is set out in the governing legislation, the statutes. The roles and responsibilities and the division of labor is kind of set out in the constating documents. Sure, but those documents come through the Act. The Act sets out our requirements. So those things like voting and dividends, participation, share subscriptions, stated capital, stuff that's maybe a bit beyond today's presentation, that all comes from the Act. It's a creature of statute. And that's really important because as lawyers, we go back to the law, and the law tells us what we have to do. Now, we know that from time to time people don't do all of these things, and there are ways to kind of clean things up over time, to rectify, for example. But building a house is a good analogy. You kind of start from a good foundation, you're constating documents and build up. You're going to have a strong foundation and less issues in the future. If you're trying to do financing, so on and so forth. We'll get to those in a little bit. But time for the funny analogy. Corporations are like ice cream. Matt hates this analogy, so he refuses to make eye contact with me. But your articles
It's only because I hear it so much, because it's so good.
well, I mean, ice cream is very good. We didn't rehearse that.
No.
But the articles, they are the ice cream cone. They are the guts, they are the base. And the first scoop of ice cream, that's the shareholders. They subscribe for shares, those shares are issued to those shareholders. They pay money, they get the shares. Okay, great. Those then elect the directors. Those directors consent to be directors, taking on certain personal liability. Go through that in a minute. But hey, we'll be the directors. And those directors that appoint officers, the president, secretary, treasurer, etc. That's your third scoop of ice cream. And keeping that in mind, a nice Neapolitan, beautiful ice cream cone, keeping that in mind will help conceptualize how things work in the corporation. Hey, I want to remove a director. How do I do that? Well, a director can resign, and then that resignation will be accepted by the shareholders. Why? The shareholders elected that director. Okay. Hey, we're changing the president. Okay. Well, the directors appointed the president. Okay. So that president will resign, and then the directors will accept that resignation and appoint a new president. So it's a check and balance. And whether it's Bell Canada, Rogers Bell, or ABC, Mississauga Inc., same governing legislation. Some nuances if you're publicly traded, not today's presentation doesn't really go into that, but think of it the same way. It's kind of a uniform way of dealing with the affairs of the corporation as set out by the constating legislation. So along that vein, we've kind of covered these points a little bit, right? So the shareholders, they actually pay money, and it's something called stated capital. And there's a concept that you're taking your after-tax dollars, you earned hard money, you've got T4 income, whatever it might be, and you're going to subscribe for 100 common shares. Okay, great. What are common shares, by the way? Common shares typically grow in value. Preference shares have a right to be paid typically first or disputed their portion first and not really participate afterwards typically. And special shares have special attributes like super voting rights, etc. Not important for today, but figure I'd get the buzzwords out of the way. The name doesn't really matter, it's the rights attached to them that really matters. You gotta really look at those articles to see what rights are attached to them. But those shareholders, they own the business. They're our first scoop of ice cream. They're right there, they elect those directors. And those directors, they oversee the day-to-day. So they're managing in the sense that they're overseeing what's happening day-to-day in their advisory role. But if certain things are not paid, now what type of things? You might conveniently say these are government-oriented remittances, CPP, taxes, those type of things, environmental liability. Those directors have to consent to say, you know what, we're going to take on the liability to make sure those things are paid. But they're going to appoint and oversee the officers to be their hands on the ground to actually do the work. And those officers, they manage the various business functions of the corporation as set out in the bylaws. What does the president do? Check the bylaws. What does the secretary do? Check the bylaws. And it's important to say that there's no specific qualifications for officers, but for directors there may be. So it depends on your governing legislation. Sometimes you're required to have a certain portion of the board be resident Canadian, and you got to check the act for what that means, or the related legislation for what that means. And in Ontario, we're not as worried about that. Same thing with Nova Scotia, PEI, BC, I believe as well. Other places like the federal government, so Corporations Canada, the CBCA, and other jurisdictions have that residency requirement. You have to be over 18, not an undischarged bankrupt. And those things are important because otherwise you can't be a director. Okay, but that's not the same for officers. So just bearing that in mind as well. And you need to have at least a president and secretary. We typically have a president, secretary, and a treasurer. It just helps our bylaws flow a little bit better.
Now, Kevin kind of touched upon the idea that directors need to consent to be appointed or to be elected for the sole reason that there are certain liabilities that are attached to directors. Now, when we first started talking about corporations, we said it was a good way to protect the business owner and separate liability, and that is true. However, in smaller corporations where it's a single shareholder who is also the director and sole officer, that business owner who is also the director still has certain types of liabilities and risks associated with that. And that is because statutes themselves attach specific liabilities and responsibilities on directors. Now, that is more so in the case of in the event that the corporation doesn't fulfill what it's supposed to do. So, for example, directors have personal liability for any unpaid wages of up to 6 months. So if at the end of the day the corporation doesn't pay the employees and there's an eventual lawsuit, that individual director has responsibility. There's also director liability for any types of remittances and withholdings that the corporation is required to do, taxes, etc., as well as any type of compliance with environmental orders. So if there's an order under environmental law to clean up a hazardous waste site and the director decides not to do that or otherwise tells the corporation not to do that, that director is personally liable. Now, there are certain ways that there can be protection of liabilities for directors. For example, under the OBCA, or the Ontario Business Corporations Act, and under the Canada Business Corporations Act and similar legislation, a corporation is able to indemnify a director. Now, there are sort of caveats though. That indemnification only works if at the end of the day the director has acted in good faith and honestly with the best interest of the corporation in mind. So there are limitations to the liability indemnification that directors offer, but at the same time you have other ways to protect officers, their directors and officers, liabilities, errors, omissions, etc. But at the end of the day, it's important to remember that just because a corporation has been sort of used as a business structure for an individual, at the end of the day, that individual still has some type of risk, especially if they are the sole officer or director, or at least a director of the corporation.
All right, time to roll your eyes again. Those lawyers, they're going to try to pitch me on more things I need to pay money for. You know what? It's probably what's going to happen. Well, not really. So it's important to acknowledge that we do step one of following the articles. We do step two of organizing, right? Issuing those shares, electing the directors, appointing the officers. And that's it, right? Easy peasy, lemon squeezy. Except for not, because a corporation's like a child. It has to be maintained and supervised and overseen and kept in good care. And the statutes, the governing legislation requires certain things. So those things are as such. Okay, my fiscal year end is December 31st. Okay, great. That's my tax year end for the corporation, which you can set the end of any fiscal month that you want, subject to the act. Okay, great. Well, now what? Okay, I got these financial statements from my great accountants. What do I do? Well, if a corporation is a separate legal entity, the directors have to review and approve those financial statements. They don't just get automatically approved. Some people say, I saw the bottom of the financial statements, I signed the bottom. That's not how approval happens. Approval happens under the Act by passing resolutions. Okay, great. Well, we also want to confirm our directors and our officers. Nothing's changed. We can keep operating, great. And you don't have to wait to your year end to do this, you can change them intermittently, but you want to confirm them on an annual basis. And then you also want to consider waiving your audit requirements. What is an audit requirement? Well, I'll give you an analogy. If Matt has a corporation and he's the sole shareholder, he's the sole director, the sole officer, if he wants to get an audit of the financial statements, he doesn't need a lawyer or an accountant, he needs a psychiatrist. Because he is the one who's approved the financial statements. And in his role as shareholder, he's wearing a different hat. It's pretty hard to say there's something funky going on here, right? Unless this is a concern about the accountants, okay? But probably not. Really, that audit is, hey, what's been the ongoing management of the corporation? Well, Matt's been in those functions. That doesn't make sense. But when there's a disconnect between the shareholders, the directors, and the officers, those shareholders retain that right to do it. And typically for small and medium-sized businesses, if you don't waive your audit requirements, that's fine until you have an issue. So as we mentioned, shareholders agreements talk about rights, various buckets, that kind of stuff. If there's an issue, typically the first thing people do is they demand an audit. Well, if you don't waive your audit, you can go back in time and require audits. So it's important to acknowledge that you don't have to have, this happen all the time, but you accrue risk by not doing it. The other thing is, okay, as you operate your business, you might want to take some money out, right? Shareholders want to return on their investment, right? Put money in, take risks, they want return. That can be in the form of salary if you're operating the business, T4, or it might be by way of dividends or management bonuses. Okay, well, if you're going to declare a dividend, the Act has a very specific mechanism for doing it. That mechanism is a resolution declaring the dividend, designating that dividend into one of three types, being a capital dividend, an eligible dividend, or an ineligible dividend. Call up your local accountant, they can tell you all about that type of stuff. It very much depends on the nature of your business. And then you have to sign something called a solvency certificate. Usually the president signs saying, hey, by paying this dividend, we're not going offside with any of our creditors. It's a process, and it's important to document that in time so that it's properly chronologically documented, and also in the case of an audit. You're allowed to pay dividends. You're allowed to declare dividends and pay them if you follow the process. Otherwise, it can really just be income. So there's a process to follow to ensure that you're keeping in compliance. But maintenance goes a little bit further. Right? We talked about step 1, step 2, and annual maintenance. There's been some changes of late. I'll let Matt kind of run through over here.
So as Kevin was mentioning, there's these sort of internal corporate documents that need to be prepared and maintained on an annual basis. Those are your annual resolutions, any types of dividend resolutions, etc. There's also returns and filings that have to be done with the ministry for tax purposes, for general upkeep purposes, etc. And there's a risk if a corporation doesn't let the ministry know each year, hey, I'm still operating, I'm still in existence, things are still going. There's an automatic administrative dissolution for failing to complete that the corporation is open to. Now, it doesn't necessarily mean that all of a sudden, if you fail to file an annual return, the corporation is dissolved. But at the same time, it's at risk of being put on notice that, hey, you haven't really maintained the corporation since when you incorporated in 2007. Now,
the other part of it is that this has been a requirement for federal corporations or CBCA corporations for a long time. Fairly easy to do. Log into the portal, do it yourself. The Ontario government changed this requirement recently. Mm-hmm. So it used to be when you filed your corporate tax return, it automatically said, yep, clearly you're alive still. You filed your tax return. They told the ministry, you know what, it's still alive. It's recently been separated, so it's a separate filing that's required. Again, it can be done directly on the Ontario Business Registry, but failure to do it does open you up to administrative dissolution. So quite often clients say, just do it for me, help me out. What about registers and ledgers?
Now, registers and ledgers, they kind of are the opposite of the annual returns in that they're not necessarily public documents. However, they are required to be kept. They're the internal documents of the corporation as well. It lists out who are my shareholders, who are my directors, who are my officers. And a new requirement that came out just at the beginning of this year is a transparency register. And that basically says, okay, well, who are my ultimate controlling entities and individuals? So, okay, I have a corporation that's been set up, and it's ABC Co. ABC Co's sole shareholder is another corporation, 1, 2, 3, 4. Okay, on our shareholder register, we might show that 1, 2, 3, 4 is the sole shareholder of ABC Co. holding 100 common shares. And that's fine for the shareholder register purposes. But this new register, this transparency register, you need to drill down further. You need to get down to the individual who has and is able to exercise substantial control. And that's generally understood to be as about 25% of the voting shares or the ability to control or otherwise direct the corporation. Now, this transparency register, again, it isn't registered with the government, but it is required to be maintained under the Act. And if you fail to do so, and the government requests to see it, or there's an audit of your books and it's not there, there's administrative fines and penalties as well. So this is just an added layer of sort of corporate compliance, but it has a purpose. It's meant to help Canada and the Ontario government fulfill their anti-money laundering obligations, etc.
As Matt mentioned, you're required to keep the corporate record book, the minute book, up to date in digital form or hard copy, either at the registered office or the designated office, the lawyer's office. And keeping it up to date is what's required in case you get audited. So you have to be able to produce this minute book. If you get audited by a CRA, who comes in and says, wait a tickety-boo, we've seen all these dividends you've been declaring. Okay, all right. We want to make sure those are done properly, fine. Well, the financial statements prove okay. But more importantly, who actually owns this corporation? You don't have to file it with your Schedule 50 your tax return. But what you do have to do is have it in case you get audited. Okay, they can come and see, they can audit your minute book to flow it through. Again, this is an example of another CBCA or federal corporate requirement that's come down to Ontario recently. I won't spend a ton of time on this. I will invite you, if you do want to know more about this process, to visit our website, kmblaw.com. On the top right, you see the public square. We have a number of quick 5-paragraph articles on common topics for business owners. And one of them is how to move your business from a sole proprietorship to a corporation. But because a sole proprietorship is one form, and a corporation is another form, and we've already shown our hands a bit about what our favorite form of operating a business is, what do you do if you've been running a sole proprietorship for a couple of years? You've got Mary's Cookies. You've been running it for a couple of years, and you set up Mary's Cookies, Inc. You set the legal entity, it's a corporation. But you've got goodwill, relationships, contracts, customers, etc. You've got assets like fiscal cookie baking oven, other stuff like that. Various assets you want to move, recipes, etc. You want to move from your personal name over to the corporation. Well, how do you do that? Well, the challenge of doing it is you got to kind of decide what your route's going to be. Okay, we're chugging along the 410. Am I getting off at Courtney Park, or do I go up the 410 to Steeles? How am I going to do this? That's the analogy here as well. Well, you got to look at sitting down with your accountant, deciding, hey, what are my options? So from a legal point of view, if you have contracts that are in your sole proprietorship, look at the contracts and do I have assignment provisions? Can I assign those contracts over to the company? Okay, that's one way I can do it. If you have those hard assets, those recipes, etc., okay, what are their values? How much goodwill is in here, etc.? What should I do? Okay, well, you can sell some of those hard assets over and trigger tax. It's a separate legal entity. You sold it over. Same way if I sold something to Matt. Okay, or you can do what's called a rollover. And again, visit kmblaw.com, the public square, moving your business from a sole proprietorship to a corporation. A rollover is just about this. The Income Tax Act says we acknowledge that, you know what, Mary's Cookies, sole proprietorship with Mary's Cookies Inc., the entity, is controlled by the same person, it's Mary, okay? We're gonna let you defer the tax. You don't avoid tax, you defer the tax. So you exchange those assets over to the corporation, and you take back a number of preference shares, typically equivalent in value. And over time, you redeem those preference shares and pay the taxes. You do trigger the tax at that point. And the idea behind that is you do a rollover agreements and resolutions. You work with your accountant to get a step memo. The lawyers implement it typically. That lets you not have to pay that load of tax up front. Now you might say, well, the cost to have a lawyer and an accountant work on it versus the cost of selling and trade the tax might not be worth it. Well, that's the decision you gotta sit down with your accountant and your lawyer and figure out. But if that's how you do it, you've got those vehicles. Do I get off at Courtney Park? Do I just sell over the assets? Or do I get off at Steeles by going up to 410? Do I do a rollover? You have choices. That's the flexibility in corporate law. Now, why don't you tell us about some of the quick hits? We've incorporated a company, we've articles of incorporation. What are some other things you can do to change the nature of your corporate structure?
Sure. So, for example, Kevin talked about at the beginning, when you file your articles of incorporation, what's inside there? Your name, the number of directors set between your range, your shares, and your share attributes. Okay, that's fine. Maybe when I was a sole individual, the sole shareholder of the company, one class of common shares was fine. But now I want to bring in someone else, and for tax purposes and for other purposes as well, I want to have now two classes of shares. Well, I can't just write on a piece of paper that I now have two classes of shares. I need to file a document, and that document is your Articles of Amendment. Articles of Amendment, they go ahead and they change what's already been created in your existing Articles of Incorporation. So you can change your authorized shares, the share classes. You know what? Now instead of each share having one vote, dividend rights, and participation rights, now it's only the Class A common shares that have voting rights, and the Class B common shares now have non-voting rights. So that's one of the ways that you can go about changing the corporate nature. Now, Articles of Amendment also have the ability to change the name. You know what? When I just started as a numbered company. I didn't really need a name, but now I'm starting to get ready to market, sort of build my brand reputation, some goodwill. I want to have a name attached to it. So in order to change the name, you also need to file Articles of Amendment. Now, Articles of Amalgamation are different. Earlier on, Kevin had mentioned when determining whether you wanted to incorporate federally or provincially. Hey, I have 4 different CBCA candidate corporations. Well, that's a little messy. There's too much going on. One of them is kind of dormant, not really doing anything. What I'm going to do is I'm going to amalgamate them. And this is when you combine your corporations. So you combine 2 or more corporations into a single legal entity. Now, when you do that, there's certain documents that deal with, okay, well, how are the shares in one corporation now dealt with in this new surviving entity? What's the name of the surviving entity, et cetera. And that's dealt with your amalgamation documents and your amalgamation agreement itself. Okay, well, great. Next step is a continuance. So I have my Ontario corporation, but now I've realized that there's a great business opportunity out in BC. I want to continue out to BC because I'm actually going to move out there and pursue this business opportunity. So in order to do that, I don't want to leave my company behind in Ontario. I'm going to continue it into BC and carry on there. And so those are continuances, and they're dealt with by each individual jurisdiction, sort of separately and uniquely. And then the last one is Articles of Dissolution. Okay, you know what? I've run my company. I'm sort of done operating this. It didn't really work out. Or at the end of the day, I'm sort of winding up the business. I don't want to be a cookie maker anymore. At the end of the day, I can file Articles of Dissolution, which basically dissolve and wind up the corporation. Now, when you dissolve and wind up the corporation, there are specific things you're required to do. You need to file your final tax return. You need to deal with the assets. Okay, all my creditors have been paid out. What do I do with the remaining assets? And that's where, again, the participation rights of the shareholders come into play. And that's the general quick hits of the sort of terms you've heard us use in the past presentation.
Now for kind of some summary remarks. So there's 3 ways to run a business: sole proprietorship, partnership, corporation. The lawyers love corporations. Corporations are separate legal entities. You not only set them up, but you have to maintain them. And there are certain transactions that are fairly straightforward to be able to do when you do them all the time. And there's other ones that are a little bit more challenging, but you can certainly do yourself. You can file your own annual return if you want to. There's nothing wrong with that, as long as someone is doing it so that you don't get administratively dissolved. But there are other things that might be a bit more challenging. Hey, I want to do an amalgamation. Well, that's the kind of thing that a corporate lawyer does all the time. There are lots of really good firms in the GTA, in the West GTA area that can help you with that. We hope we're one of them. We're hoping this information is helpful, but know that you can rely on law firms such as ours to be able to help out with these type of transactions, because they'll be probably quicker, cheaper, and done correctly in a way that'll let you focus on operating your business. So we think of ourselves as professional advisors to be able to help you to free up time and headaches so that you can run your business and do what you do really well. And with that, it's the question slide. And I've seen a couple of questions pop into the chat, but I'm going to hand it over to Stephanie to kind of moderate the chat here for us.
For sure. Thank you to you both. Great presentation. Remember to enter your questions in the chat, or if you would prefer, you can unmute yourself and definitely ask Kevin or Matthew live. So we do have a question here, and it says, do all shareholders, even minority, have to sign?
In terms of, I think this question came up when we were talking about the waiver of audit rights.
Potentially. Maria, do you maybe want to unmute yourself?
And just to say that the answer is yes, because at the end of the day, the audit rights are specifically meant to protect minority shareholders. If you're a minority shareholder, you're not necessarily, you might not be given the right to or the ability to elect a director. And so you're not given that active and behind the scene information of how the corporation's been operating. So if you want to waive that audit right, you're going to have all the shareholders approve the audit waiver.
It's a protection for shareholders, whether they're minority, majority, but more typically for a minority shareholder who doesn't have that same access.
Now, it's important to note, though, that we should be waiving the audit rights on an annual basis as well. So there's always some tricky case law and decisions in the courts that involve minority shareholder disputes. And one of them is the idea that, you know what, just because I've waived my right maybe for the first year of the corporation, that doesn't mean 10 years down the road, I'm still waiving my audit rights. And this is why doing your annual resolutions and your annual maintenance will help keep that audit waiver fresh and up to date.
It also helps to identify potential issues early. So as you run the cycle a few times, people can have a chance to check in with one another. People can look at their shareholders agreement and decide what they want to do vis-a-vis their rights. Do they still want to be involved, not? And have an active participation. So even if someone is a passive shareholder, they're still an owner of the corporation. And being able to do that kind of health check in a regular and systematic way, the same way that your bank, your account manager visits you every year if you have a credit facility, checks on how you're doing. The same way you do your financial statements with your accountant every year, checks on how you're doing. That same check-in process with your lawyer and your shareholders can help you deal with a lot of different issues. I see Victoria had a question as well, Stephanie.
We do, yes. We got another one in. And I just want to mention, I am okay to share your presentation, right? Kevin and Matthew, for anyone who is asking. The file is quite large, so we're just trying to compress it a bit. But if anyone does want a copy of the presentation, let me know and I can send it out.
We can always turn it into a PDF.
We can shrink this file size as well. Yeah.
Okay, perfect. Yes. So we do have a question from Victoria. If employees in a corporation is found to be involved with any type of crime, such as money laundering or bribery, would the corporation as a whole be liable, or is it the directors that become responsible?
Well, that was very case specific, and it depends a lot upon the role, their agency relationship, their ability to hold themselves out, something called the indoor management rule, where they representing themselves as being in a position where someone can rely on this rule that, hey, we thought this person was in care and control. They were able to bind the corporation. Now, if it's an employee, we're not talking them as a shareholder, we're only talking them as a director or officer. Seniority is important there, and their rights as an employee and their obligations as an employee are really important as well. More than just corporate law obligations, there's a number of obligations as an employee that kind of kick in, probably more actually important than actually the corporate statute that's applicable.
Yeah, no, I was going to say it is it is tricky and case specific when you get down to those anti-money laundering and sort of fraudulent activities. There's always some form or case to be made, usually for vicarious liability connecting to the corporation itself. But as Kevin mentioned as well, it gets down to beyond just necessarily the corporate statutes, but also employment issues as well.
The structure we provide is a framework. So how it's implemented and goes down, okay, we have our directors, they oversee the operations, the officers, they actually do the day-to-day. Well, policies, procedures, attestations, processes are super important when it comes to being able to discharge that duty. So for example, I used to work at a large company where every year we would sign off on training, we would do training, and sign off on an attestation about insider trading. And I wasn't a very senior person, but everyone that had exposure to that business function had a requirement to engage in it. And now that I'm a lawyer, I understand it a little bit better in terms of, hey, what's my due diligence defense? We brought it to someone's attention every year, we had training, we stressed the importance, and it still happened. What more could we have possibly done? That due diligence defense is really important. And also that processes thing is really important when it comes to selling a business, which is beyond today's scope. That's probably about 65% of what Matt and I do, buying and selling businesses. But repeatability of results is important. If a potential buyer is coming in to look at a business, they want to say, hey, what can we do to plug ourselves in and know things are going to run like a well-oiled machine? Well, if you have processes in place, checks and balances, things that can kind of say, you know what, let's replace Joe with Mary. Okay, this thing will still run. It can go a long way to providing that comfort and increasing probably your purchase price and likelihood of closing.
Great, thank you. We do have another question in. Do I need to wait to close the year to change from a sole proprietorship to an open a corporation?
Not necessarily. You should talk to your accountant about what's the easiest to do from an accounting point of view, right? You're running your business up to a certain point, great. And then all of a sudden you want to run the business through another vehicle, the corporation. What is going to be the best from a financial tracking point of view in terms of operating that business? Like for example, middle of the month is probably not great. Right now we're in the middle of corporate tax season, probably not great. But looking at things that help that accountant support you, and in our business, we tend to have some busy seasons, but generally it's overall busy. You're not going to find a time that's better, other than that, I spend a lot of time at the golf course in the summer. But besides that, it's because we're being involved in the community. That's how I justify it, of course. But it's important that, there's no ebb and flow really in our practice. You want to do that now, you want to incorporate now, or in 2 months, it doesn't really matter. But in terms of booking transactions and keeping your financial health and matters organized, really that'll be the tail that wags the dog.
Great. I'll give everyone another second or two to enter any questions, or if they want to unmute themselves to ask Kevin or Matthew a question. Okay. So I just want to thank you. Oh, sorry, we do have one. Yes, Ferris, go ahead. You can unmute yourself.
Oh, thank you very much. Just a quick question. Thank you very much for the presentation. It was amazing. You've mentioned the new requirement for filing the returns and the registers. The corporation will not, Ontario will not immediately dissolve me because I did it in 2020. I incorporated in 2020, but my lawyer did not come back to me saying, "Oh, you need to do the filing and the returns now because it's a new requirement." Do I need to reach out to them?
There is no automatic dissolution as soon as you fail to file one of your annual returns. But what should be done though is filing those returns sooner rather than later. So you would file your 2021, then you would file your 2022. The registers themselves, though, I should clarify again, though, like the director's register, the officer register, the shareholder register, the transparency register. Those are all internal documents. They're not necessarily filed with the corporation, with the Ministry or Corporations Canada. You do obviously submit to them who your directors and officers are, but the registers themselves are internal documents.
There's also one more register in Ontario. You have to keep a register of interest in real property. So in land, you have to keep a register in there. So in case a corporation dissolves and there's land they can't find who owns it, they can trace through where it's got to go. Although I don't have any more comments to share on this public forum on that. When it comes to the dissolution part, it's a process. So they only brought this requirement, I think, last fall, not one prior to that. And so there's still some kinks being worn out, right? The Ontario Business Registry worked really well, and then it froze and it worked really well, and they're kind of working through some things, right? It's a growing process. I will tell you, for a client of ours that, and I see Brandon is on the call here, so he knows what I'm talking about here. We have a client that he and I were working out how to help the guy run his business. We went online, Corporations Canada, administrative dissolution pending, because he hasn't filed his annual returns. So at the Corporations Canada level, they've already got a process in place, and it's publicly available. Just letting you in on a secret, you can look up any federal corporation using the Canada Corporations Canada search, and you can see who the directors, the officers, the articles. You can see the registered office, and you can see whether they've done their filings. It's free, it's online. So what's important is that the Ontario Business Registry, I see following that. It hasn't quite got there yet, but they typically, in the example of my client who's on the verge of being administratively dissolved, they sent them a note saying you got an extra 120 days to do it. Now, arguably, if they give you an extra 4 months to do it, really is that much of a deadline? But they don't just kind of wake up one day and do it, although it's kind of embarrassing, right? If you're going to sell your business and your minute book looks like a hot dumpster fire, it doesn't really tell people that you have a lot of care and control, your filings are up to date, because they can see what day they were filed. When they were due, when did you file? It lets in a good corporate lawyer can sniff around those things and kind of tell their client, you might want to scratch a little bit deeper here. You know what, this guy's not been paying a lot of attention to what he's doing, and that may or may not impact the level of due diligence, the amount of goodwill transfer, and the relationship between the parties as you potentially sell a business, for example. And that's a legal term. Hot dumpster fire is actually a legal term.
Great, thank you. And we are at that time. I want to thank you both for joining us today. Thank you again to Kaiser Mason Ball for hosting this webinar. We look forward to seeing everyone at our upcoming events. Check out our website, mbot.com/events. We have our mayor's annual address coming up on April 18th and our reception with Mississauga's politicians. So definitely check out our website, visit us, and register for all our events. We look forward to seeing all of you soon. Thank you, everyone. Thank you again, Matthew and Kevin. Appreciate it.
Take care. Bye. Bye.